All right, we are live. Thank you for tuning in. We should be live on all platforms. I appreciate y'all. We are going to be going live with subject matter expert Ryan Thompson on the Soldiers Home, also known as the West Los Angeles VA. That's right, the West Los Angeles VA. And we're excited to talk to him. It's a lot of this is going to be regarding a lawsuit. If you've heard of the lawsuit Dennis versus McDonough, it's the lawsuit regarding the West Los Angeles VA, and we are going to do a deep dive into that lawsuit and that issue coming up here right now. So give us about 5 minutes or less than 5 minutes here, and we will be live. Maybe some music instead of. Unless it'll be a copyright issue. I could go do 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 do. Sorry. By the way, if you're just pulling up, let us know in the chat where you're tuning in from. Let us know in the chat where you're tuning in from. We are going to be getting going on this interview, this discussion in just under 4 minutes.
I am doing Instagram. I'm doing Instagram. Instagram is not working. I do not know why.
Take the link on Substack and send it in the chat on Substack. That could help. Maybe then I could see it. Whoa, this is tripping me out, the thing above me. We need that countdown.
Can you try Instagram on your end? For some reason, it's definitely not working.
Yeah. What about Substack?
I'm checking that right now.
Go here. I usually copy the title. We had it perfect that time on Substack. Like flawless. I can't recall, was I on their website? I think we're about to be live on Instagram, but we'll see. Hey, can you restart the countdown? We are live on YouTube. Thank you for tuning in. We are just minutes away from the discussion with the subject matter expert, Ryan Thompson, regarding the lawsuit surrounding Powers versus McDonough, I believe is the title of the lawsuit, in court right now. We are going to discuss it and have a conversation about it with the subject matter expert, Ryan Thompson, coming up here in just a few minutes. We've been trying to go live on some other platforms. I don't know. Working. Can't go live on Instagram. Let's see. Edit. Stream keys. I'll try it again. Alright, stream key, edit, paste, save. Are you kidding?
I am getting Substack going in about 1 minute. I figured it out.
All right, cool. Amazing. You could hear me, right?
Clear as day. We got 51 people in here from YouTube and TikTok.
Yeah, I see. It's a good mix. Yep. Wait, maybe that's what I had to do. Oh yeah, dude, simple. With Instagram, you gotta re-toggle the on-off, I think, after. I don't know, at least I think that's what's gonna do it. Yeah, that's what did it here. So we're now live on Instagram. We are now live on Instagram. What's up, everybody? We are just minutes away. And if Instagram freezes, I don't know what to say, but I think that's just Instagram. We are just minutes away from a discussion with the subject matter expert Ryan Thompson regarding the West Los Angeles VA, the Soldiers Home. That's that big property, that land donated over 900 acres in 1888 to be nothing but a permanent home for homeless and disabled veterans. And you ask, why is Los Angeles our nation's capital of veteran homelessness and suicide? And we are going to discuss the lawsuit. It's a lawsuit in court right now. It's a lawsuit in court right now that is see here. It's a lawsuit in court right now that it's important that we all we discuss, we learn about, we talk about, and we get the facts regarding this situation. So thank you for tuning in. We're just minutes away from the subject matter expert Ryan Thompson joining us. Are we live on Substack? We are?
We are officially live on Substack.
Sweet. So we're live on Instagram, Substack. I'm trying to see the live on mine. If you could drop the link in the chat. Oh yeah, I see. I actually just got an email of it, so that happened as I asked. Watch this live video. Yeah, here we are. I see us. Beautiful. Thank you all for tuning in. Sorry for the delay. Just a few minutes away. So I got that chat. Thank you. Substack in the building. Substack in the building. Ryan's going to be joining in just a minute. He's compiling documents and information for this.
We are officially live everywhere. Instagram, this, YouTube, TikTok,
discussion.
Substack, everywhere. We're live.
Wow, beautiful. Beautiful. Well, this is a good time to remind people that Substack is the best place to subscribe, to join the work we do. We are updating the checkpoints. There's a live chat in there. And your support allows us to continue this investigative and independent journalism. We're excited to have Mr. Ryan Thompson coming up very shortly here. What up, Renetta Williams on YouTube? What's up? She said, hey, Mr. Checkpoint. How you doing? Let me know if you're in the chat. Let me know where you're tuning in from. Let me know where you're tuning in from. Let's see. Oh, wow, the Substack chat's popping. What up, Alex? What up, Susan? What up, Jen? What up, Sharon? Oh, here we go. We got Ryan. What up, Ruthless in the building? We got the subject matter expert, someone I respect greatly. I met Ryan in 2020 at at the soldiers' home when the sheriffs were there, and I was told to go to the meeting from Rocio. Uh, Rocio is someone who was out advocating with her husband Brian Alvarado, and uh, Brian is a victim of the burn pits actually, and they would be out on the streets regularly. Anyway, she tipped me off. Hey, the sheriffs are going to be at the VA, and I went for that particular reason. Before that, I had, of course, seen the tents on the curb and the American flags, and it was concerning being born and raised from LA. And I got to learn and work and see the work that Ryan Thompson has done regarding this particular issue. So, if you could, Ryan, and want to introduce yourself, and the floor is yours.
Sure. Is my audio working?
It is, but yeah.
Okay, cool. I'm
Yep.
sorry, this camera's like looking down on me. I just can't seem to position it a different.
I think be louder though, if possible.
Okay.
But
How's that?
we could hear you.
Is that better?
Yeah, it's
Okay.
good.
Let me know if my voice falls back later. Anyway, what this is a public briefing about something that those of us who across the country are following issues regarding disabled veterans who are homeless and non-disabled veterans who are homeless in regards to the National Soldiers Home. And what we've been hearing a lot about, over the, progressively over the past 2 or 3 years, but especially over the last 8 months or so, is about a federal lawsuit called Powers v. McDonough and the subsequent appeal of that case that is in progress in the Ninth Circuit Court of Appeals in the state of California. And almost unanimously, what I see that we're hearing and seeing and noticing from media reports and punditry is that the United States federal government, which is being sued in this action, is holding up the orders, these heroic orders of a federal judge named David O. Carter, and that the VA and the Fed are expressly, intentionally holding up housing that is, basically causing and perpetuating homelessness, international capital of veteran homelessness, aka Los Angeles County. And what all of these integrated media campaigns are putting out there is that, Carter's orders are there to save, homeless veterans and disabled veterans and their rights to their National Soldiers Home, and to get rid of the illegal land use that practically the whole country knows 3 times over is there causing veteran homelessness and thereby veteran homelessness death. So we're going to take a look at the orders. And there's a lot of filings in this case, but we've put some time into organizing them in a manner in which, we've pre-highlighted, very important sections of those orders. And we're going to kind of go through them in the most logical and comprehensible way I believe we can, given their complexity. So before we do that, I want to make sure that everybody knows, if you received an email from me, you will have, or passed it on to someone else, there will be a link in there to a Google Drive link. That Google Drive link is going to have actually even more than the evidence and information and the orders that we're going to present in this, just to provide as much info as possible. And in there is going to be a subdirectory that is labeled marked, M-A-R-K-E-D. That is going to, that directory is going to have the specific orders and final judgments that are going to be pre-marked with underlining of what we're going to exactly go over in this at least. So you can go there right now in those links and you should see them there. The necessary background, I think, to be contemplating in context of what we're going to hear is either a reminder or maybe new to some folks. And that is many times over, for decades now, for many decades actually, whether it be the congressional record, whether it be a federal court judge, whether it be the inspector, the OIG, the VA Office of Inspector General, whether it be the press at certain points in time, whether it be veteran services organizations, especially when they were more proactive with their non-conflicted advocacy. We know that the illegal land use at the soldiers' home is illegal. We know that it causes veteran homelessness. We know, as the people of the United States, that it kills them with that homelessness. And those are people that we have already paid for 137 years and counting in full for our United States federal government to house them at their national soldiers' home. And it is called a national soldiers' home because it's a national home. It is always intended and mandated and exists perpetually to be a home for veterans who are unemployed, disabled, and or homeless, who need a home. They are entitled to it, and they are entitled to it by unwanted disability and homelessness. This isn't something like, yeah, I'm going to go get disabled or become homeless because I want a room there, okay? Additionally, there was a lawsuit in 2011, a civil rights lawsuit, federal lawsuit, Valentini v. Shinseki. That lawsuit, two of the most important things to contemplate right now before we go into this, is that lawsuit was expressly about the illegal land use causing homelessness and a move to get rid of it, as well as to shut down an attempt of calling the Soldiers' Home a charitable trust. Regarding the charitable trust, while that term sounds pretty nice when you say it, and in many ways in its enforcement and execution in the private sector, it is. But there is not a charitable trust at the National Soldiers' Home. It is perpetually deeded for the purposes for which it is perpetually deeded. The reason a charitable trust has come up in legal battles has been as a scheme to, based on charitable trust law that does not apply to this and often is not even federal law, to claim that the federal government has breached a charitable trust that doesn't exist so that lawsuits can ensue by the heirs and heiresses of the supposed original benefactors of the almost 1,000 acres deeded of the Soldiers' Home accepted by acts of Congress, so that they can take them back. And there were even deals made ahead of time with law firms in LA. I think O'Melveny and Myers was one of them, even in the 60s, where the heirs would pre-sell their rights in case they could win off of a case like that to recapture the land that they didn't personally donate and turn it around and sell it and launder it, of course, with the consequence of homelessness and death. The other thing to keep in mind, so in this lawsuit, Valentini v. Shinseki, the homeless veterans who were homeless, who filed that suit, won that suit. They won that suit around this time in 2013. What they won expressly stated that the illegal land use, everything, all of it, illegal, moot, and void, time to go. And that included Brentwood School and UCLA. There were no caveats attached to that. It said if an appeal did not prove successful within 180 days, that even the stay on that order would be dropped. Brentwood School then came in with UCLA and they tried to intervene and or appeal in that case after the homeless veterans won that civil rights case back in the summer or fall of 2013. Their arguments were very weak. They primarily relied upon trying to purport that they didn't know the case was going on, even though it was all over the news. Judge Otero slammed them down for that, stripped just about everything they had in their attempted appeals and interventions, and forewarned them expressly in his orders that to try to hang on to the almost nothing they have and persist with those appeals and interventions would probably not work out for them. Nevertheless, they persisted. However, something happened. About 2 years after the veterans, almost 2 years after the veterans had won that federal civil rights case against the illegal land use, suddenly Brentwood School and UCLA abandoned on their own accord those attempted interventions and appeals with malicious intent. They had malicious intent for abandoning them too, because they believed that they had fooled the people of the United States of America, along with some lawyers pretending to represent the homeless veterans after Valentini v. Shinseki. They had thought that they had pulled off a lie to fabricate that there was a settlement of the Valentini case. And the document that they waved around claiming was a settlement of a case won almost 2 years prior, not only expressly states that it is not a settlement, that maybe a settlement might be reached one day in the future. It also states that the plaintiffs weren't involved with this scheme. It was the counsel without them. It also states that the solution and the settlement and the new way forward is going to be by replacing the veterans, the homeless veterans across this country and the disabled ones, with philanthropists, bankers, family offices, real estate developers, and fraudulent nonprofits that were going to replace Veterans Voice and the Veterans Authority and the VA's authority that cannot be replaced in this matter of the permanent deeds accepted upon acts of Congress. And they also stated, the other part was that the veteran plaintiffs who already won this case wanted to throw their winning judgment orders in the trash. They were going to give them up and didn't want them anymore. Well, one of those plaintiffs was a congressionally chartered veteran service organization that is still around, albeit under major attacks by corruption involved with this matter. And we do have their statements in emails and statements that they wrote to their membership that they didn't even have any idea that this was going on. They didn't understand it, and it looked like they were screwed and that they were not part of it. So this was a major fraud upon the people, upon the veterans there among, and upon the soldiers' home. And that was the foundation by which it has been rested, the position that all of this fraud causing us to persist as the national capital of veteran homelessness would somehow be maliciously valid. Now, that so-called settlement also claimed that because of this brilliant criminal idea that they were going to be ending veteran homelessness in Los Angeles and beyond by the end of 2016. Well, we're still waiting, and it's 2025. And that illegal land use has proliferated since then, as we're going to understand. So advocacy that I have been involved with on an unpaid, volunteer, unconflicted, full-time basis since 2019 had basically proved out in discovery that there was no settlement. It has never occurred. It was a big lie. And I want to, substantiate that too here by just mentioning that was done, including by methods where the United States Department of Justice Civil Rights Division issued a responsive letter on letterhead stating that they had no record of any settlement of the case. Of course, that is who represented the defendants in the United States government in Valentini v. Shinseki. And that also Mark Rosenbaum, who is the attorney with public counsel, 2 times on record in conference calls recorded, admitted it expressly. It was just a piece of paper. Somehow we're here today. Somehow this continues to go on. So shortly after we reminded the people of that truth and proved this out, and I want to say, while the lawyers pretending to ethically represent the veterans after Valentini were notified by the Otero court that we figured this out, as you will notice on the docket of Valentini v. Shinseki in February of 2020. They never, not a single time, tried to do anything to help whatsoever. But what they did when finally it began proving out that the settlement never existed, they rushed to file a new lawsuit and to deceive good people, whom are the remaining plaintiffs in this Powers v. McDonough case, to use and exploit them to hurt homeless veterans by causing more homelessness and thereby death thereof, and a robbery of we the people's public funds. And so the Powers case had filed this complaint. The complaint you will see is in the repository link that is provided. And these attorneys who are involved, we have primarily a Roman Silberfeld with Kaplan Robbins and a Mark Rosenbaum, public counsel, as lead attorneys. And Rosenbaum is the one who admitted the settlement didn't exist, which is true. And also Mark and Roman They are staff of the University of California, and they have offices over on the Irvine campus, unless that recently changed. So does one other person, Judge David O. Carter. Judge David O. Carter, in this Powers v. McDonough case. The plaintiff's purported counsel, as well as the judge, who conducted a bench trial without a jury, are all with the University of California, that is also stealing that baseball field to hide methane operations, and of course has a long history of very unethical research on veteran test subjects. So the last thing I'm going to say before we go into this is to steal, because this is not always so obvious. If someone's going to steal land, right, such as the National Soldiers Home, and use it unlawfully for other purposes, such as a 450,000 square foot mega mall with a hotel, selling alcohol, such as double charging veterans who have no money because they're homeless. Market rate rents are 160% over market rate rents in a scheme that double bills the taxpayers who already pay the VA budget to house and care for these people with these new vouchers that were meant for the private communities, because those vouchers go directly into the pockets of the developers who unlawfully were awarded enhanced use leases in which they make $0 payments for those leases while receiving every single cent from the public that they want for anything that they say is needed there, whether that be renovations never even performed, services that aren't even being provided. So if you want to steal that land, you're going to have to and use it for those purposes, alternative. You're going to have to get everything on that land off of it. And I think that we generally are, have a pretty significant awareness now and understanding across this country that about the part of getting rid of the veterans and putting them back out into homelessness. But I think we ought to overlook that you also have to get rid of the only other thing that is allowed there, which is us, our federal government, our United States of America federal government. So that is why I believe that in the Powers v. McDonough case, amidst all of the talk it has to rile us up and make us all feel good about it because of our good hearts, that it's really going to show down the illegal land use. The lawsuit is in no way, shape, or form ever at any point in time a lawsuit against any of the illegal land use. It is a lawsuit by ourselves, against our own federal government. Because whether it is done by deception, a little bit of bribery of a few public officials, whatever it takes, we need to, it's a divisive, diversionary tactic that I believe is criminal to put us against ourselves and rob us out of something of ours as a people. And a lot of people's lives depend on that. So with that in mind, I want to start looking at these orders that we keep hearing about that are supposedly so wonderful about the Powers v. McDonough case, not in terms of the plaintiffs in that case, who are good people, but in terms of what's fooling them. So Senate, just so you know, the first document I'm going to start with is the final judgment. And
Okay.
in the marked directory, if you see that, Senate, on the Google Drive link.
Yep, Mark Directory. Yep, I'm here.
Okay, great. So the document we're going to open is at the end of that file name is going to say 0358.0. The document's going to be final judgment. It'll say final judgment and permanent injunction.
Okay.
So in this document here, we are looking at Judge Carter's final judgment, order, and permanent injunction of
Wait,
August 6th.
ending in 03580?
I believe so. Does it say on the first page final judgment and permanent injunction?
Yes.
Okay, great. So
All right,
in
so
this document, I want to point a few things out. It says that the class, the plaintiffs are a class, and that this is a class action. And the class is consisting of all homeless veterans with serious mental illness or traumatic brain injuries who reside in Los Angeles County, and homeless veterans who have been or remain unhoused or at risk of being unhoused, and a subclass of all class members whose income, including veterans' disability benefits, exceeds 50% of the area median income. So in short, as we can see, when we think about this, in another pass, what it's saying is some of the veterans in the United States of America are the class. Some of the veterans of the United States of America who are entitled to their national soldiers' home when they're homeless, a fraction of them are who this class is. This is the beginning of a fabricated argument that we have seen being pushed by this land grab racket for ages. And that is to deceive us into thinking that the need for the soldier's home must only be calculated against some of the homeless people in parts of Los Angeles who have certain medical conditions, or to try to, reinforce the HUD-VASH scheme that's going on at the home, or are making more than 50% of the area median income. We understand, many of us at a surface level, the issues with the disability compensation, but that's playing on the fraud's court, because the overarching point that makes it moot is if you're already paying for these folks to be housed there for 137 years in the VA budget, which is now the current request is over $425 billion, and the National Soldiers Home is the biggest and busiest VA facility in the United States of America, we don't need to be giving buildings away and giving money away for these existing housing buildings to be renovated or not and poorly run. So it's trying to say that the class also pertains to people that are locked in to trying to establish and reinforce this HUD-VASH scheme also, okay? So again, the fallacy of that is that is only a fraction of those who are entitled to the national home. That is not an accurate representation. The plaintiffs in the case, they are entitled to the soldier's home. That is their right. But that is not the only description or category of veterans whom are homeless or disabled that it pertains to. In fact, it's not even close to how many it pertains to. It also says that the court certified the class and subclass on May 3rd, and then the court granted partial summary judgment in favor of plaintiffs. It said the court conducted a bench trial that began on the 6th of August and ended on September 6, 2024, and it issued a post-trial opinion, findings of fact, and conclusions of law. So we're going to take a look at those documents and filings by the court that it is saying are part of its final judgment. So we're going to move on to here momentarily to a document that ends in 0190.0 in the MARC directory. And the front page of that says order granting plaintiff's motion to certify the class. Do you see that one, Senate?
Yeah, it'll be up on the screen in just 2 seconds. And give me 1 second before
No
you continue so it's on the screen. Replay sharing. I'm just gonna this one. It's this one, I think. Does that look great?
Yes.
Okay.
So a couple things I want to point out at this filing that Carter declares as part of his judgment order. This is an order as to how he certified the class. So under section 2, it says legal standard. It says the courts may certify class action only if it satisfies all 4 requirements identified in Federal Rule Procedure 23A. And it says under the description of that in subparagraph 3, the claims or defenses of the representative parties are typical of the claims or defenses of the class. Well, the technical issue with that is the plaintiffs were housed at that time and housed where they are fully entitled to be housed, but that is not representative of veterans who are homeless at the time. It also says the representative parties will fairly and adequately protect the interests of the class. Well, at the head end of this, we preface this discussion, talking about Attorney Mark Rosenbaum, public counsel talking about Roman Silberfeld, and it just so happens to be, of course, that back from the Valentini v. Shinseki fiasco, right, about fabricating a settlement, that same attorney, Mark Rosenbaum, is the one who organized and filed this action. He is the lead attorney, purportedly for the plaintiffs on this case. So I don't understand how one can begin to say that it is qualified that the representative parties will fairly and adequately protect the interests of the class. Furthermore, it says a class action may be maintained under Rule 23b2 if the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that the final injunctive relief or corresponding declaratory relief is appropriate respecting the class as a whole. Well, it says if the party opposing the class has acted or refused to act on grounds that generally apply to them. So here we go again. There are officers and officials in the VA and in other public offices who have been, to one extent or another, unduly to illegally influenced to breach and not perform their mission and their oath to the people, and especially homeless veterans and disabled veterans. And that's the part that is constantly publicized, that we know. But the fact remains that just about almost all of what is causing this homelessness, what the veterans who are there are complaining at the national home are complaining about, and what is keeping the veterans who want to be there out directly, okay, are the illegal land users. The illegal land users are the ones who sue veterans and the government and try to divide them. They are the ones that steal the land and bar and obstruct veterans from using it lawfully. They are the ones that are robbing the Treasury for services and programs and actions never performed, or at least poorly performed. That's not our own federal government. We have folks in the federal government that they bribe and they influence to then throw them out like rope-a-dopes for us to punch, so we can forget that we're punching ourselves. But that is not the primary cause. That is the gatekeeper and the enablers that need to be dealt with. So this lawsuit is not regarding the party opposing these plaintiffs. That opponent is nowhere to be found here in this case that is conspiratorially designed to protect them. If we go to the next page, it says class counsel have a duty to fairly and adequately represent the interests of the class. When deciding whether a class counsel is adequate to carry out this duty, the courts must consider 4 factors: the work the counsel has done in identifying or investigating potential claims in the action, their experience in handling these sorts of things, and the resources the counsel would commit to representing the class. I don't think any further description is necessary there. I think it's just to be asked, is that counsel sound anything like that in terms of representing those plaintiffs? It also says under Section 3 discussion, the class is all homeless veterans with serious mental illness or traumatic brain injuries who reside in Los Angeles County only. It says the subclass, all class members whose income, including disability income benefits, exceeds half of the area median income of, Brentwood, Westwood, West LA, right? So if we go to page 5, it says, the court finds the plaintiffs have met their burden to demonstrate the subclass sufficiently numerous. Actually, you know what? I'm going to skip that one. I just can't remember. Oh, actually, sorry. We're still on page 4. My bad. It says the court finds that the proposed class and subclass are sufficiently numerous. As plaintiffs point out, the VA itself cites data showing that 1 in 5 people experiencing homelessness in the United States is seriously mentally ill, citing a U.S. Department of Veterans Affairs report. So the judge is saying we are to presume that, 1 in 5 veterans is mentally ill and homeless when they're homeless because the defendants in this case said so. It then says that, again, 3,874 veterans in Los Angeles indicates that those veterans, that at least 779 of them are experiencing severe mental illness. This number is likely higher for the veteran population, as research shows. Well, that research they cite is a white-labeled RAND study that I think, that is basically funded by private developers. I think Epstein's one of the biggest ones. I forget his first name. RAND is not evidently in the business of doing empirical, diligent, ethical work when it comes to homeless veterans. They are in the business of taking money from private developers and stamping their brand on it in studies that covered, a look at 5 veterans, sometimes less, who complete the surveys or the research. But Carter goes on to say this figure alone is sufficient to establish that this is the class instead of all homeless veterans and disabled veterans who need a home in the United States of America at their national soldiers' home. It says the court accordingly finds it's satisfied. So then it says in legal standard on page 5, courts are required to perform a rigorous analysis to determine whether there are questions of law or fact common to the class. Commonality obtains when the class members' claims depend on a common contention of such a nature that it is capable of class-wide resolution. So this is saying that Carter was supposed to perform a rigorous analysis of the issues common to the class, and whether that depends upon a common contention. Well, it may among those good people who are the plaintiffs in the case, but it doesn't really relate to the effective commonality of every homeless veteran in the country, up to the capacity of that national soldiers' home to house them without illegal land use. If we go to page 6, it says, under discussion, plaintiffs, however, are not requesting any individual grant of housing for any particular class member. Rather, they're challenging a government policy, asserting the defendant's failure to provide permanent supportive housing on or near the West LA grounds. Here we have Judge Carter saying, and the plaintiff's counsel saying, which I do not believe any of the, just saying I don't believe it, that any of those plaintiffs have ever said it, that they are not requesting housing for homeless veterans. They're instead challenging a policy. They're challenging a policy that the defendants failed to provide a certain type of housing that requires the laundering of the land to private developers. And that is how they are defining permanent supportive housing in many other purported findings and research. It then goes on to say in page 7, plaintiffs point to federal defendants' failure to build adequate permanent supportive housing on the West LA grounds and their choice to enter into numerous identified leases and land agreements that they contend do not comply with the VA's fiduciary duties. They identify the defendant's use of income eligibility criteria which exclude the members of the subclass from permanent supportive housing on the West LA grounds. That makes sense to me. It makes sense to me that the plaintiffs in the case are against the illegal land use. I definitely believe that they are. But as we go further into looking at these orders, it's very astonishing to see how that is not represented. It then says on page 8, defendants primarily argue that several plaintiffs placed in permanent supportive housing on the West LA grounds who seek appointment as class representatives may be subject to jurisdictional defenses, including that their claims are moot. Due to recent policy change by HUD that it would authorize public housing authorities to utilize available vouchers. Well, the part about HUD and the housing authorities is an important point, because as we said, all of these buildings have been taken over and stolen, right, and rerun under these HUD-VASH schemes that can last no longer than 20 years in any one project, despite their 99-year unlawfully awarded enhanced use leases. It is showing right here, as proven true, that the Housing Authority of Los Angeles is involved a lot with making these policies. Yet somehow the plaintiff's counsel and the judge, who all work for the same University of California, didn't find that very interesting and didn't feel that the Housing Authority of Los Angeles had to be involved with this case, I guess, to any significant extent of consequence. It also says that that's not the VA. It says that something else is happening by someone else at the land the VA is to be the steward of permanently. Then on page 9, it says, plaintiff's placement in permanent supportive housing on the grounds does not moot their case as a reasonable exception that they may become unhoused again in the future. So it's trying to say that a class of only a fraction of the veterans whom are homeless or disabled in this country, whom are entitled to their national soldier's home, they are that just fraction should be legitimately considered fine as a class representatives, because even if they are housed, they might be unhoused in the future. My only comment to that, in addition, is that it's a bit defeatist. It's a bit defeatist to think that way, given that when the home has run properly, it created the city of Brentwood. It created the city of Sawtell. Veterans prove their worth when they heal and leave the home, when they're not being defrauded to death by illegal land use. It also says, while some plaintiffs have been housed since the complaint was filed, plaintiffs point to evidence of veterans placed into housing who then lost their vouchers due to HUD-VASH's staff failure to complete certification renewals. Well, as the Inspector General reported and found in January of this year, it's not the HUD-VASH staff, it's the developers who also say that they're the HUD-VASH staff to get the grant money who are failing their job. So that is the private developers folks who are where they're removing the United States federal government and VA from running the soldiers' home, who are actually doing that. Then we go on to page 10. It says, plaintiffs argue that the proposed class representatives and their counsel adequately represent the proposed classes, and their representation would not be compromised by any conflicts of interest, and they will vigorously prosecute the action on behalf of the class. Well, let's remember that for later. So, I'll leave this document at that at the moment. I think that kind of covers this enough about the certification of the class, other than I do notice that there are plaintiffs. If I remember correctly, about half of the plaintiffs in this case left the case. And I think they might have done so, at least many of them, before this document, but they were still being named in the case on the docket. So I think that's worth noting. I at least know that one of those plaintiffs did expressly feel that it was not an ethically operated case, to put it nicely. So then we go to the other order mentioned in Carter's final judgment, and that is the summary judgment order. It says that on page 3, in 2011, 10 unhoused veterans with severe disabilities sued the VA for its failure to provide housing on the West LA grounds.
Let me get that.
Oh, I'm sorry. Yeah, so that document ends in 0218.0.
02.
And that document is entitled Order Granting in Part Plaintiff's Partial Motion for Summary Judgment.
Yep. I'll have it up in just a second. Looks like it's this one. Oops. There's this weird note on it where it
That's probably just my underlined notes or whatever, but if we go to page 3 of that. Okay. So Judge Carter writes here, in 2011, 10 unhoused veterans with severe disabilities sued the VA for its failure to provide housing on the West LA VA grounds. To settle that lawsuit, so he's not saying Valentini v. Shinseki here, but just know that the name he's not saying is Valentini v. Shinseki. To settle that lawsuit, the VA pledged to draft and implement a master plan to provide housing and supportive services for veterans. Pursuant to the master plan, the VA agreed to build 1,200 permanent supportive housing units for veterans on the West LA VA grounds. 760 were to be completed by 22. In 2021, the VA Office of the Inspector General reported that the agency had not constructed a single new unit of permanent supportive housing. Well, let's talk about that. For some reason, it's not really important, I guess, to mention that that lawsuit is the federal civil rights lawsuit, Valentin v. Shinseki, that the veterans won, that was never settled, in fact, and that the folks who were initially trying to say that it was settled have since confessed. You tell me what you hear for yourself, that was just a piece of paper and it was no settlement. That's true. And regarding the master plan, here's the reality of the master plan. The master plan is the deeds. And the master plan is the performance of the United States federal government in building all of that housing, whether it's by the Board of Managers, the Veterans Administration, or the United States Department of Veterans Affairs, building and operating all that housing until at least from a standpoint of building, until 2017. From 1888 to 2017. That is how long they've been building housing. However, by declining amounts as the illegal land use proliferates, and on a rapid scale beginning in 1972, right? Because in 1972, 1 year after the Sylmar earthquake on the other side of the mountain, the valley, that destroyed the Sepulveda VA and required the patients in that hospital that were still alive to be transported to the Soldiers Home Hospital in West LA area. 1 year after that happened, 1 year after the Federal Engineering Task Force showed up and confirmed that there was no significant damage to any of the housing buildings there, at which point approximately 5,000 veterans who had been homeless were living at their Soldiers Home, at a point where there was barely understood much of a thing called veteran homelessness in what is now our nation's capital of it. And it became our nation's capital of it because a UCLA proxied group of primarily folks hiding behind UCLA purported that somehow they could officially declare 1 year after the Sylmar earthquake that a lot, I forget exactly how many, but many of the housing buildings filled at capacity with formerly homeless veterans were potentially damaged. And in respect of those veterans' health, almost 2,000 of them were evicted into homelessness in under 2 weeks, at which point we became, as we remain, the national capital of veteran homelessness. At which point UCLA research, often hazardous, moved into many of those buildings. The 2021 statement that is made about the VA Office of the Inspector General saying the agency had not constructed a new unit of permanent housing. Well, beyond what we just understand about them being the only folks who did it, to the point of between the 50s and the early 70s of having upwards of 5,000 there at any given time, on any given night. The VA absolutely did recently finish the full remodel of Building 209 so it could once again house homeless veterans taken off the street. And they did not pay rent because the rent was already paid by us taxpayers, paying the rent for those who cannot, who need that home, as deeded through our massive United States Department of Veterans Affairs annual budget at the biggest VA facility in the country. And that remodeling, which was for about $38 million, included a full roof replacement of a Spanish tiled roof. The VA ran Building 209 from 2015 to 2017. But then what happens is the racket that comes in waving around a fake settlement paper of a settlement that never happened kicks the VA out with the help of some public corruption, I presume. And they claim in a second ribbon cutting that they had done the remodel. And suddenly there's something called an enhanced use lease unlawfully governing the building, and rents are being charged, which are being covered by double charging taxpayers for HUD-VASH vouchers. But because all but 6 of the 64 veterans living in that building could find a way to quickly qualify for HUD VASH, they were kicked to the curb on the street, homeless, and replaced with ones who could qualify. If we go to page 4, it says, among more than 75 propositions considered by the National Home across dozens of localities was an offer by Senator John P. Jones and Arcadia DeBaker to donate 300 acres. 2 300-acre deeds for the home were donated on the same day. Carter, I think, messes up and actually mentions that later in a different document. And those 600 acres are of almost 1,000. And to this very day, you can just simply go to the Bureau of Land Management's website and take a look at those records, proving it out without contention. Then it says on page 4 at the bottom, admission to the soldier's home was simple. Any discharged soldier or sailor of the Army or Navy in the United States may gain admission by laying on the adjutant's desk in his certificate of honorable discharge and pension certificate, if a pensioner. That statement that is cited from is from James J. Fitzgerald in his writing Soldier's Home of California in 1922. Well, James J. Fitzgerald, he's an author, but he's not part of the government and he's not an authority. And that's not true. You had to be homeless. Why is this choosing to pick this offbeat citation to provide a false impression that a veteran did not have to be homeless? So then if we go down to the last page, page 30, under disposition, it says, the court holds that the VA's practice of leasing its land to third-party housing developers who use restrictive income limitations vastly discriminates against veterans based on their disabilities. Well, you know what? Yeah, there is a fault in the VA officials who have been doing that. But what about the third-party housing developers who are using the restrictive income limitations? Where are they? They're nowhere to be found in this case. It then says further, the court holds that the government's acceptance of the land transferred under the 1888 deed created a charitable trust, and the VA has enforceable fiduciary duties to the veterans under the charitable trust. The separate question of whether the VA has breached those duties is reserved for trial. Well, we talked about the charitable trust. The only other thing we need to know about it is if you go in the directory that's been provided, you will see that that was already tried in the Valentini v. Shinseki court, and instead of in one paragraph, Judge Otero issued an order, comprising 8 or 9 pages of explanation as to why it is not a charitable trust and the scheme involved with that. It is permanently for our United States government to permanently house disabled and homeless veterans. And that is the duty of our government, not anyone pretending that they're the heir or heiress trying to put forward a charitable trust matter that's already been tried and founded not to be true, that they seem to have amnesia about here in the same courthouse of Valentini v. Shinseki was held at. And just to indicate further as to why that's how much that's been a big interest in this land grab. Back in the federal civil rights suit of Valentini v. Shinseki, a woman claiming to be the heir of one of the donors, who was actually the wife of a donor, which was Arcadia Bandini, she was found not to be a legitimate heir, and she was ejected from the case. That's how interested they are in that. So now we'll go to the other order mentioned in the final judgment, which is number 302. And this is where we're going to get a little more interesting with less background and more present issues. And that document that ends in, it starts with DKT.302, post-trial opinion, findings of fact, and conclusions of law. Let me know when you see that, Senate. Great. So on this document, it's going to go through a lot of rhetoric about things that sound pretty good for a good reason. But let's say on page 14, it begins to say on page 14, plaintiffs have proven that the VA has violated the Rehabilitation Act by denying veterans the benefits of VA healthcare services, programs, or activities in the most integrated setting appropriate to their needs. There is nothing that is any prevailing authority that puts upon a prevailing pedestal that the overarching duty at the Soldiers' Home is for the United States government to provide the benefits of the healthcare services, programs, or activities in the most integrated setting. What integrated setting means to land grab in a deceptive document is a 450,000 square foot mega mall, are thoroughfares that allow the traffic through Brentwood and Westwood and West LA running all over and trampling all over that home. That a private school like illegal Brentwood School could be there. That maybe students who are medical students could live there, right? That maybe there could be alcohol sold there. Maybe there could be a hotel that veterans want that never actually wanted, that was invented in an editorial piece in the LA Times, right? That's what they mean by integrated setting. And it then says, plaintiffs have proven that federal defendants violated the Rehabilitation Act by denying plaintiffs a reasonable accommodation they need, supportive housing, but to access their healthcare services solely because of their disabilities. There's such a focus on disability here, right? The reason that they are saying, once again, that they're trying to fabricate that the only folks entitled to this, starting with only within the bounds of Los Angeles, maybe city, is that the whole thing is about these plaintiffs were not provided the supportive housing that they need for the purpose of accessing healthcare services, and they were prejudiced solely because of their disabilities. Disability is a word that UCLA has depended on for 50 years to try to substantiate its macabre and dark existence, stealing that Soldiers' Home. That is how they constantly say the need for them to be there is because every veteran is mental and disabled. And that's why they should be able to do brain experiments on them or other stuff that is not helping them. There is medical care that can be provided and is provided well in the hospital, but even that is very severely threatened these days. It is a home for homeless veterans anywhere in the nation, right? They don't just have to have a mental illness if UCLA says they do. They don't just have to be in Los Angeles. It says also the plaintiffs have proven that federal defendants violated the Rehabilitation Act. I already read that, sorry. So it says plaintiffs are therefore entitled to the injunctive relief, including the development of 750 supportive housing, temporary supportive housing, and 1,800 permanent supportive housing units at the West LA VA. So it's talking about 750 temporary housing units and 1,800 permanent supportive housing units. And here it's saying they're at the West LA VA. So let's keep that in mind as we go through these other orders. It then says on page 17, the VA contracts with meal provision monitoring page 16, excuse me. After clearing Veterans Row in the late 2021, the VA instituted pallet shelters with tiny sheds to replace the tents at CTRS. To be eligible for the CTRS sheds, as well as the VA's other emergency shelter options, a veteran must be eligible for VA health care. It then says on page 17, the VA contracts with meal provision, monitoring, janitorial, and security services for the CTRS shelters. Well, every single one of those tents except for 5 came out of my garage, and approximately 60 of those tents I solicited, to procure as donations. I was very much involved, not the person who did the most work, but very significantly involved with what was happening where we had those tents there for 2 years, while Brentwood School and UCLA and RAND and the city and the county officials in LASA and many others, in addition to some bought-off folks in the VA, some bought-off folks among a lot more that aren't bought off in the VA, I know a little something about that. And I know that, one, there were 2 times that we were able to get those veterans inside. The first one is when I was provided by the BHLHS executives a press release with advance notice to review and provide my commentary on that on April 1st, 2020, they were going to bring in the folks in tents onto the grounds. So they wouldn't have to be having cars running by, swearing at them, having to crap in front of them on the street, being denied bathrooms, and having even people throwing things on fire at them. And having pay-to-play journalists acting like they're their buddies to write slanderous things about them. And so when that happened, and the first batch got in, it was quickly taken over by UCLA and Brentwood School. And I believe they even went to Congress for appropriations for millions of dollars, saying they were doing something or another there other than just making life hell, because they didn't want them there, right? And then it happened again in 2021. And they talk about when VA cleared. VA did not clear anything. The only thing VA cleared was finally letting, despite Landgrab's, overzealous objections, all the rest of the veterans who were in there, of the 350 or so that had passed through over 2 years. And when they were let in, we also provided the tents for their temporary stay in tents on their grounds until, as we expected, that the building 220 right next to CTRS, that has been empty, nearly empty, ever since UCLA stole it in a 2016 baseball lease, and therefore was no longer the female homeless veterans housing building anymore, that could very simply, without having to spend $10 million on trailers and all this mess called modular temporary housing, which we'll get into later. It only took 3 months per the contracts to renovate that building to not be used for the housing it is designed for. Why not spend 3 months while these folks are in tents to bring it back? That's a lot better than another shed. Maybe this one with a toilet. So if we go to page 17, when we saw the VA contracts, the other thing it's saying here, right, is that CTRS is all VAs, right? But that's a lie. The revocable license that was fraudulently granted to run and control CTRS was to Marcy Polier Schwartz and her Village for Vets. And she was the one who had the insurance policy when the pallet shelters that she procured with inner city law and Brentwood School and US Vets and UCLA, when those sheds that had known to be flammable without their bathrooms and without their sinks lit up in flames one night, she then tried to dump the revocable license back onto VA because she didn't even want to file the insurance claim. We have the emails. I'll be sure to update that directory with that material, since it's a reminder to myself. It says the VA has stated it is unable to pay for the tiny sheds directly, although it does use its own funds to set up utilities and prepare the sites for the sheds. So here it's saying the $425 billion a year VA that's been building stuff and doing everything there almost the entire time is unable to build anything. That's a very familiar thing that Marcy was always trying to say. And that so the sheds have historically been funded by private donations, including Arnold Schwarzenegger and the Brentwood School. But the VA is only responsible for the utilities, right? They want you to think the VA is only responsible for the thing having to do with the defect that set them on fire. How interesting. All right, so on page 18, the developer of several of the existing project-based housing units on campus, Shangri-La, has come under public scrutiny after a recent civil lawsuit brought by the Attorney General of California. Shangri-La, in turn, has alleged its CFO embezzled millions from the company. Shangri-La was the leaseholder and developer for buildings 205, 208, and 209. Trial was on August 13th of 24. At the time of trial, the court had heard testimony that Shangri-La is no longer a leaseholder on the campus. That's false. They are absolutely still involved, and we're still involved at that time. They also have an extensive ownership as of more recent times in Step Up. That is simply false. But the bigger question here is, so are we supposed to read this and be like, oh, okay, great, thanks. Let's still attack our government? Where are they? Where are they being sued in this? Where are they behind bars? They aren't. They're driving around in Bentleys with public funds. If we go to page 19, these developers can impose separate requirements above and beyond the voucher program. That is not true. Go look at the regulations, go look at the laws. But they will then need to ensure that they meet any additional requirements that the developer imposes to qualify for an apartment in a given building. That is not true either. How in the world can this judge say that the developers get to just by fiat come up with additional requirements that they decide to impose that determine the qualifications of whether or not a disabled or homeless veteran anywhere in this nation who's entitled to their home instead of the developer may be? The judge doesn't even try to explain it, right? So then if we go down to, there's a lot in here, but I just kind of try to pick out a couple pieces here, probably down at the bottom here. Let's see. Okay, so toward the end here, if we go to, let's make sure I didn't miss anything. Page 123, or sorry, 122. So as part of the therefore, Judge Carter orders, it says at the bottom of page 122, 750 temporary supportive units. The units shall be placed in such that all units are operational with 18 months, and the temporary supportive housing units shall be placed on the West LAV campus as to not interfere with current or planned construction activities that would include the provision of medical services. So, don't put them anywhere where someone might want a mega mall. Don't put them anywhere where UCLA might want to be doing research, right? And have the VA focus on that rather than, although not by the best way to approach it, all the housing that at least they are trying to push hard and that is being delivered. Again, being delivered in a partially illegal manner that will have to be dealt with, but is being delivered by the hundreds of units. And we're going to take a look at what that temporary housing means in other orders of Judge Carter. It then says, within 6 months, develop a plan for the construction of 1,800 units of permanent supportive housing within VA-GLHS's catchment area and the development of the connective tissue town center on the West LA grounds. That's possibly the biggest problem with this entire unlawful order. It's saying that the permanent supportive housing, the temporary housing, which we'll see what that is, that can be around. But as for permanent supportive housing, let's push that out to anywhere in the gigantic VA-GLHS catchment area that even goes beyond LA City's borders, while we build the mega mall with its hotel, whether or not it has a bar, at the National Slaughter Zone. That's an order. It says that connective tissue must be built under operational status within 6 years of the order. In other words, by Casey Wasserman's Olympics. It says at the bottom of 123, federal defendants shall commence active construction of the town center within 18 months. Not housing. It says as to both temporary and permanent supportive housing units, the court, Judge Carter, will retain jurisdiction to adjust the number of units in each category in order to closely approximate the actual need for housing. And let's remember that need is what he fabricates is only within Los Angeles City, if we're talking about homeless veterans. It then says on the last page, 124, any permanent supportive housing that is built on the West LA VA grounds shall be the most efficient, affordable, and shall employ the most efficient, affordable, and time-sensitive conventional financing of its housing projects. What they're saying there is it has to be this flavor of permanent supportive housing that's unlawfully being awarded enhanced use leases, stealing the buildings for zero lease payments, and getting all the rest of the money they want from the federal government to charge veterans who are homeless a second rent of 160% the market rate going in the developers' pockets by double billing the taxpayers after we've already been paying for this in the now $425 billion United States Department of Veterans Affairs budget. And I wish I could say that's all, because as far as it looks right now, it does also seem to appear that these developer cartels are imposing the charges of at least 30% out of even CalFresh and general relief compensation that veterans are getting that's supposed to be paying for their food. So they're oftentimes now starving in a permanent supportive housing unit of a stolen building. The next one we're going to go to is a document that ends in 0309.0. And that document is entitled on the first page, Order Enjoining UCLA from Accessing Baseball Facilities on the West LA VA campus. That's in the mark directory as well. Are you seeing that, Senate? You there, Senate? Maybe the mic has gone down. Let me check here.
Can you hear me? Hello, hello, hello.
Yeah, I can hear you now. Okay, great. Is that up? Document 309.
The title of it again?
Yeah, so the title of it, it's a document ending in the mark directory in 0309.0.
Okay, yep. I'll have it on the screen in 1 second here. Should be this one, I think. This one?
Great. Yeah, so this is the next order that is mentioned as part of the final judgment from the district court. And that order, as we can see here on the first page, says UCLA is not allowed to use the stolen baseball field that's already been ruled illegal, right, many times over, and its other facilities at the Soldiers' Home, until UCLA proposes a position on how the 10 acres it currently occupies can be put to a use such that the provisions of services to veterans is not the principal, not the primary, but the predominant focus of the activities of the regents at the entire campus, not just in one place. So again, you know, we hear all the tough talk and all the, you know, the low angle wide shots, you know, presenting a stoic Judge Carter, rocking around holding court, often outside of the federal courtroom. But here he is proposing that UCLA by order must stay. He locks them in to the Soldiers' Home until a plan can be figured out that we're going to believe or be deceived to believe is good for them to stay. We're then going to move to the next order that's part of the final judgment. That document ends in a file name of 0310.0. That's an order about the parking lot. Okay, so now we're going to move on to the parking lot. All that big, bad illegal land use that we heard tough talk about. Within 7 days, the VA shall obtain from Safety Park all accounting records related to operation of the parking lots on the West LA VA campus dating from the last accounting prepared by Safety Park for fiscal year 2021. If the VA fails to produce them, the plaintiff shall immediately issue a subpoena for the same records, which are due for return in 10 days. The VA shall commence a recompete process for the operation of the parking lots, pursuant to applicable governing regulations, beginning September 26, which shall be completed within 90 days. Any operation of the parking lots must, include the employment of veterans, right? So here's Judge Carter right here in the actual orders of his final judgment saying, we're gonna give a bunch of time, several months, for folks to figure out a plan of how to repackage and resell the same exact illegal land use, even after it's already resulted in the FBI and the OIG busting criminally and imprisoning it for millions of dollars in frauds, having to sell off the fraudsters collections of cigarette boats and exotic cars in Florida condo penthouses, so that the new way can be the same stuff, same crap, but maybe it'll employ a veteran, right? That sounds like to Carter, I guess, a lot better than a Soldier's Home. Then we go to document that is called, at the end of the document, 0311.0. Okay, this is the next order in Carter's final judgment order. And it says, order mandating Bridgeland Oil to cap Sawtelle 2 and setting a status conference. First, it says that there was a 2017 lease to Bridgeland, which it was not, it was to another company, in exchange for the right to operate Sawtelle 2, which is a certain illegal oil well that's being operated on the surface of the Soldiers' Home, as well as underneath it. And then it says that that agreement provides donations of a 2.5% royalty to a veterans charity. Well, Sawtelle 2 is one of many, many, many wells and operations illegally occurring by these frackers and crackers above the National Soldiers' Home without any legal standing, and have often gone bankrupt over and over again. More companies come in. It also, beyond only talking about one or two wells, which I think if we look at the records anyway, it shows that maybe they already may have been out of service. It also is talking about, what it also is not talking about, besides all these other wells, is the methane. When they built a gated mansion community on top of what was then LA County's biggest landfill dump, just above the Soldiers' Home past the Getty, when they capped that off with the gated mansion community tract, that means it becomes a ticking time bomb for all the methane as the garbage erodes under it. And so UCLA came up with a brilliant plan to stick a giant straw into that landfill underneath and unlawfully pump down through what Brentwood School says it needs for a baseball field, through the illegal golf course, through the illegal baseball field UCLA stole, and through the new practice field they built during COVID illegally, and then into that fracking cracking operation, at which point it is cracked into a more stable liquefied gas mix, right? They leave the hazardous stuff over for the Soldiers' Home, and then they pipe it under the Soldiers' Home Cemetery and the stolen CNH tract right into the big turbines next to Ronald Reagan Hospital at UCLA to have historically, if not maybe still do, deliver up to 80% of UCLA's demand for electricity on campus. I think that's why we see a lot of shallow illegal land use developments in a vertical line going from the Getty to that cracking operation. In the second paragraph, the bottom paragraph, it says, Bridgeland has represented that since the court's order, it has ceased extracting oil using the Sawtelle 2 well. I believe it. I believe that at one well of many, they have ceased operations only involving oil. It then says on the last page that Bridgeland is hereby ordered to cap, using procedures consistent with California law that has no jurisdiction there, Sawtelle 2, so that Bridgeland may no longer slant drill private oil leases from the West LA campus, capping Sawtelle 2. So make sure that we are aware of that, slant drilling. All right, so then we go to the next order of the final judgment order of David Carter. And that document is called Emergency Order 1, filed.
Emergency 1 filed, you said?
Yeah, Emergency Order 1 filed.
Found it. Here it is.
All right. This is the next part of the final order. Now we're going to talk more about temporary housing. On page 1, it says, there's this urgent need to place temporary supportive housing on the West Los Angeles VA campus. The court and counsel for the parties and representation of the parties, and experts for the plaintiff's class, namely experts that are Steven Soberoff and Jonathan Sharon. They are going to begin the process of identifying parcels of land suitable for the placement of temporary housing units to shelter homeless veterans. Signed, David Carter. Now let's look at the last page of this order, where the areas to choose from are circled. The outskirts of the Soldiers' Home, particularly where you have very well established high levels of unhealthy toxicity due to the radioactive waste dumping of UCLA for decades, due to the unlawful oil and gas operations, and from an industrial standpoint, down there by all the hospital operations and everything going on there. Of course, this would either be done by taking parking or taking land that would be absolutely toxic to be on. That is what Steven Soboroff, the expert witness for disabled and homeless veterans, on behalf of the ones who never chose him, believes is suitable, as does Judge Carter. And then also notice here that there's yellow where it says PSH. I thought we were talking about temporary housing that really is shelter, but it's here, it says PSH, permanent supportive housing. So now it's also saying that, well, by the way, if you're still going to build permanent supportive housing, hint, hint, maybe you should do it over here, you know, by the post office and down there by the hospital after the purple line is done, destroying all that land and building a big hole below it. Maybe that's where you can move any remaining permanent supportive housing, because all this other stuff in the middle, that's what we'd like to call downtown Brentwood, with a hotel that we don't know whether or not Soboroff wants it to have a bar. So now let's go to the next final judgment order of David O. Carter's. That document is entitled, ends in, or it says Emergency Order 2. So here on page 1, it says the post-trial opinion held that there's an urgent need to place temporary housing, right? They forget to mention permanent, on the West Lafayette campus. Representatives of the parties, experts for the plaintiff's class, they've met to find places suitable for temporary supportive housing units to, again, shelter veterans. Within 30 days, one or more vendors of modular housing are to be identified by experts. The vendors for modular housing shall qualify for consideration only if they're able to deliver and install 50 of them in 45 days. And collectively, and a purchase order for collectively 200 to 300 within 90 to 120 days. Any procurement rules applicable to VA are hereby suspended. VA shall pay the costs associated with the purchase and installation of the modular housing, site preparation costs, and infrastructure connection costs contemplated by this order. So what we have here is we're going to redirect our focus into trailers, somewhere between sheds and trailers on toxic lands, that Soboroff is going to tell us where they're going to be. The VA is going to pay for it all. And, just in case maybe they won't, someone won't have toilets, maybe someone won't have sinks again, we're going to suspend all the procurement rules of our VA that's supposed to pay for it all. So that's that order. We're getting almost to the end here. So now the next order of the final judgment ends in 0357.0. So let's see what this order, sounding nothing like any pay-to-play media you've ever witnessed, cover. On page 2, well, it's called Permanent Injunction Regarding Former Brentwood School Leased Grounds. On page 2, to ensure the land is put to a use that principally benefits veterans, the court will determine an exit strategy for the Brentwood School's 22 acres following the hearing on injunctive relief. Keep in mind that exit strategy, as we're about to see, doesn't mean eviction. It means an exit strategy from a current legal lease to something else. We've already seen that in a fake settlement. It then says, whereas Brentwood School has participated in the hearing on injunctive relief and other concerns, the monitor and the court, whereas Brentwood School has agreed to a settlement agreement that would ensure its prompt implementation and the immediate accrual of benefits to veterans and their families. Whereas the U.S. Department of Veterans Affairs was invited to be part of the Brentwood School settlement agreement, the VA has chosen to object. The Brentwood School settlement agreement is contingent upon the court, as referenced below, entering an order that the VA and Brentwood School enter into a form of enhanced use facilities sharing agreement or lease that permits Brentwood School to use the VA land. Brentwood School is being granted the right to share access to the land. The principal focus of the 22.6 acre enhanced facilities use sharing agreement with Brentwood School that is the subject to the Brentwood School settlement agreement is so that veterans and their families will have access as set forth herein. It is unlikely that, at least for the near term, the VA would build or be in a position to maintain the athletic facilities that are currently under the 22.6 acres of Brentwood School's absence. I guess that means it would be unlikely that the U.S. federal government that has built every single solitary unit of housing there up to the capacity of 2,000 to 5,000 on any given night between 1888 and 2000 and 1972, and then by declining rates there from there down to when I got started in this, less than 100, back up to, I guess, around 1,300 now. Those folks, not the folks who never actually built anything but had to do it illegally, had never delivered a unit of housing until 2023 in Building 207, after everyone was kicked out of there, 110 veterans, and sat there vacant forever. It's the actual performer that can build the housing, that does have the budget. It doesn't seem like they would be able to do that. And of course, that's contemplated in context of only considering veterans who are homeless in the city of Los Angeles that had severe mental illness. It then says, whereas Brentwood School is not a party to the case. Absolutely true. It then says on page 3, whereas plaintiffs allege one of the driving issues in the class action is the desire and need for housing for disabled veterans. So on page 2, it's saying that we probably wouldn't need that housing for disabled veterans, right? On page 3, it's saying that the plaintiffs believe they do. Well, that is true. I wholeheartedly believe the plaintiffs believe that correctly. That's why they're distinguished as being separated from whatever else they're talking about on page 2. It then says, whereas the court has been approved in principle the Brentwood School settlement agreement and agrees and finds that it complies with the West LA Leasing Act and that it principally benefits veterans. Whereas the plaintiffs in the court have determined that the Brentwood School settlement agreement contemplated and the consideration to be provided from Brentwood School is consistent with VA's mission and operations and will help revitalize the West LA campus for the benefit of veterans and their families. How many people have died on that line? The plaintiffs recognize that Brentwood School will be a key partner in the support of veterans on the West LA campus and that preserving the relationship with Brentwood School is in everyone's best interest. Whereas Brentwood School is a not-for-profit independent school, it owns 8 acres of land contiguous to the West LA campus. Plaintiffs contend the VA first began allowing Brentwood School to use its property in the mid-1970s. Those are very deceptively important statements, because what's being kind of danced around here is that there is not a single solitary square millimeter of land called the Brentwood School East Campus that is not actually the soldier's home. Brentwood School has no legitimate deed. It can't even evince anything that looks barely believable as to anything outside of the 22 acres it illegally leases, that it has any believable anything indicating that it owns it. But I can definitely tell you a big part that is very evident as to what helped them seal the deal, they think, on trying to steal it not too long ago, was a guy named Jose Huizar, who's now sitting in prison. He had been running the LA County Planning and Land Use Commission back then. And between him and some lobbyists, they helped make that happen. Not for long. Then we have on page 5, the OIG determined the Brentwood School's lease violated the West Los Angeles Leasing Act because the purpose was not to principally benefit veterans and their families. Rather, the principle of this lease was to provide the Brentwood School continued use of the facilities. Very true. They also found that in 2021, and the Otero federal court had found that back in 2013. It then says on page 6, whereas the parties to the Brentwood School settlement agreement, including Brentwood School that is not a party to the case, agree that they do not need to take a position as to whether they agree or disagree with the court's rulings in order to enter into the Brentwood School settlement agreement, which is intended to ensure veterans and their families principally benefit from the land and athletic facilities on the 22 acres, allowing Brentwood to use the 26 acres of the land during certain hours and under certain conditions and for renewing terms. And it says the parties agree that in light of the court's rulings in the class action, in order for Brentwood School to be able to continue to use the 22 acres. It says, whereas in the prior lease, Brentwood School provided services for which it received in-kind credit, it will also provide services under the real property agreement for which it will get in-kind credit. On the next page 7, whereas the plaintiff's class in Brentwood School want to use and enjoy the aforesaid the plaintiff's class in Brentwood School want to use and enjoy the aforesaid property and do not want to change the current nature of the use of the property unless absolutely necessary for development of housing for disabled, I guess homeless is missing, veterans. Whereas an order is necessary to memorialize the Brentwood School settlement agreement with respect to the use and conditions of the 22 acres. I don't even think I need to say anything about that, other than I do not believe that those 6 remaining plaintiffs in this case are really excited about Brentwood School staying. I have a very difficult time believing that, and that's to say the least. Good cause appearing, therefore. There is no just reason for delay as to Veterans Administration and its affiliate individual defendants in the entry of a permanent injunction and the entry judgment thereon regarding the former Brentwood School lease grounds only, and judgment on the permanent injunction as to the former Brentwood School lease grounds shall be entered as part of the final judgment in this action as to all their parties and claims. The court has jurisdiction over the subject matter of this action and over the parties. The court. Carter. UC. Judge, jury. Carter. No notice is required to be given to any person or class of persons as a matter of law or procedure to permit the entry of this permanent injunction. There is no just reason for delaying the entry and implementation of the permanent injunction with respect to Brentwood School, and this permanent injunction may be entered separately from the final judgment to be entered. I mean, can anyone sound more criminally desperate for good reason? It then says on page 9, Veterans Administration, its affiliated individual defendants and their successors shall accept in-kind contributions from the Brentwood School. Brentwood School shall have the continuing right, subject to terms set forth herein in the Brentwood School Settlement Agreement, to use also the lower softball field on MacArthur Field. The parcel will be treated as if it was never within the agreement, next page, to be entered, but will not alter the base rental fee. In other words, they're also going to get this softball field they've been using, but they shouldn't have to pay for it. The Brentwood School shall have the continuing right, subject to other terms set forth herein, to use the upper baseball and soccer field, known as parcel lot number 9, without having to pay anything extra in kind. It then says VA shall use its best efforts to use other parcels of land in the former leased grounds for any veteran-related purposes before giving notice to Brentwood School of its intent to cancel Brentwood School's use of the entry off Barrington. The swimming pool area, the pavilion, the track and football fields, and the tennis courts are designated areas of last resort. They're core facilities of stolen land grab land causing veteran homelessness in our national capital. VA can only revoke access and use the core facilities if it is determined by either the court or the court-appointed monitor, John Heston, who's also with University of California in Irvine, of either short-term or long-term housing of disabled veterans. In other words, the last thing that should ever be picked to try to fight to be used for what it may only be permanently to save lives in according with the money we spend to save them is Brentwood School. Brentwood School's permitted hours of use, other than for purposes of access and maintenance, VA shall allow Brentwood School the exclusive right to access and use the sports facilities during certain hours to be determined, but estimated to be from 2 p.m. to 7 p.m. Monday through Thursday, 2 p.m. to 8 p.m. on Fridays, except annually published football blackout dates, without penalty or breach of a game reasonably unexpectedly requires additional time. I mean, how much more can this be worth than the lives of those we pay to care for those who bore the battle? How much more worth it is it to continue causing us, no matter whether someone thinks someone's a NIMBY or not, to continue causing the decrepit lack of quality of life we all are against being so low? For a football game to go long illegally? Brentwood School shall have full-time access for ingress and egress using the gate, driveway off Barrington, and permitted to use the parking lots as currently configured as used. The court shall retain jurisdiction to enforce the terms of this injunction. Let's go to the last order regarding the final judgment and ruling of David Carter. That is document 386. So that is order granting UCLA interim access. Because the parties reached tentative resolutions about the location of temporary housing adjacent to the UCLA baseball stadium on the West LA campus, the court is prepared to provide UCLA limited and interim access to the baseball facilities on the campus. The court will allow UCLA access to the Jackie Robinson Baseball Stadium until the end of the baseball season. The regents of the University of California's motion to modify the injunction. The baseball season includes any postseason use if the UCLA baseball team is engaged in postseason regional and or national games. Access will include the small practice field adjacent to the stadium, just stolen, known as Bronca Field, and all concessions and training facilities within the stadium. You may remember this being talked about during COVID when they were trying to figure out how, before responding to my very late FOIA, to come up with a veteran's story about how good that illegal land use would be. After extensive deliberation with the parties, the court does not believe that the stadium itself or practice field will be used as a temporary housing location before the 4th of July. If VA continues to argue, contrary to the court's findings, that there is insufficient space available for veteran housing on campus, the court will consider any available parking on these sites for UCLA. The court is hopeful these decisions can take place before baseball season begins in March 2025. In the meantime, the court finds there is adequate parking across the street from these lots, as well as almost 2 acres of parking remaining on Parcel 7 and more parking to the north of Parcel 7. The court is encouraged by the new engagement of UCLA and veterans, whatever veterans, I don't know, but reminds the parties that in any lease with UCLA, the provision of services to veterans must be the predominant focus, I guess in a statement only, of UCLA's activities on the campus under the West LA Leasing Act. Always forget to mention the deeds. The court encourages the parties in UCLA to continue discussions that have included veteran student housing and other possibilities such as the use of vacant lands owned by UCLA, including the vacant over 30-acre Palos Verdes property. Maybe we can shove those veterans out to Palos Verdes for a game of baseball and a mega mall with a hotel and a bar given away to criminals who bribe politicians for free, and the death that costs, and insolvency. And interim access to the stadium and Bronca practice field as of Tuesday at noon. This order advances the primary goal of housing. This order advances the primary goal of housing without unnecessarily keeping the stadium closed, the illegal stadium closed, until the land is needed for veteran housing. You want to talk about who's mentally ill? I'll tell you who I think is mentally ill, but maybe later. So that concludes the sum of all of the final judgment orders that somehow we are being deceived by disinformation, to misperceive by fabrication, that this is actually what is holding up ending veteran homelessness, veteran housing for homeless and disabled veterans. This is supposedly all the stuff that we need to get behind and tell ourselves, our own United States federal government, to deny ourselves our constitutional right of appeal as our federal government to put this in jail. And just about everything I've talked about here, I'm pretty sure that most of the people on this have never heard anything like it. But here it is. These are the orders. You have the original versions of them and the marked versions of them on the drive link. And I am happy to go into interactive, questions and answers, whatever at this point, if anybody wants to do that. I do need to relieve myself really quick. So if Senate, you want to, get that going, and I'm going to come back here in 1 minute.
Yep, no problem. No problem at all. Well, that was a lot of info. Thank you, Ryan. We got Commander Francisco Juarez in the comments. Carter portrayed the Patriot in the news, but these facts demonstrate backroom negotiating that gives away land for 99 years. Unbelievable. Unbelievable. Let us know in the comments if you have questions. Let us know in the comments if you have any questions. I do have to wrap up shortly. I'm going to drop the link to the Google Drive in the YouTube comments section of this video. So actually right now, I'm gonna try to, maybe I can't quite yet, but it's, well, let's see, edit video. I think I can, let's see. I'll try to drop the link. Oh, here we go. Yeah, I'll put it in the description. Paste. So that's going to be to the Google Drive. It's in the description. So triple check that. The link to the Google Drive will be there. And let's see, Commander Francisco Juarez. The Mega Mall must not be allowed because it is the linchpin that will repurpose the land from a home to the publicly accessible Brentwood City. I agree, Commander. I agree. Well, this will all be shared. This will be saved online. This will be public on the YouTube channel. So there'll be a link for this video. That link will not be going away. That link will be live. It will be public. I think we got Ryan back in here. Yep. Let's see if I can do this kind of thing. There we go. Well, I was going to say, Commander Francisco Juarez, he wrote, Carter portrayed the Patriot in the news, but these facts demonstrate backroom negotiating that gives away the land for 99 years. The Mega Mall must not be allowed because it's the linchpin that will repurpose the land from a home to be publicly accessible for Brentwood City.
Yeah,
spread the word.
I mean, and even to push the effective aspects of that statement aligned with the prevailing authorities of the use of land there, it's just moot. There should not even be a discussion. It is illegal for there to even be a official contemplation of replacing veterans' lives who are homeless with a mega mall, right? It's not even open for discussion. Just like, you know, this whole business of the county trying to pretend it owns the land of the armory, the National Guard Armory, that it had lied about operating as a 24/7 turnkey shelter for homeless veterans for 10 years, and then said, no, that's going to be because it's a winter shelter, and then, oh, it's because a new law has to be changed to allow them to do what they said they were already doing. You know, and now they're saying that they, you know, they own the land and they're going to take the existing turnkey shelter that is empty and spend a couple of years developing it into something that looks like a condo complex. You know, that discussion is worthless. It's just a waste of time because the county doesn't own that land. And we can get into that later, but same thing with the Mega Mall. Same thing with Brentwood School. Yeah.
There's a question that came in, and it says, BCT Sean, what can we as residents, especially Brentwood residents, do to restore the original land use? And for anyone watching, I'm joining this from the West LA area of Los Angeles. Ryan, if you want to give context to, you know, where you were from. And
I think, in my personal opinion, what really works in terms of what local residents can do, particularly non-veterans like myself, is to not underestimate the power and authority of our voice. You know, I definitely am pretty confident that a lot of what's happened so far that the illegal land users have never expected in their wildest dreams against them, you know, that owes some significant amount to public awareness being developed. You got to talk about this, and to further that, Senate, what you've done before in terms of providing, you know, really readily usable online forms that can immediately send out emails to elected officials and others, where people can, you know, make their voice heard about their perspectives on this. And I think the perspectives, you know, that I would suggest considering being made would always, you know, revolve around, I'm sick of veterans dying homeless on the street. I've realized that if I'm not ignorant in thinking that, you know, veterans are criminals even, and all these things they're slandered as, it still means that the illegal land use is causing the lowering of my quality of life. Whether I believe the slander or not, if they're homeless out in the streets here, that is lowering my quality of life, you know? And I think it's important to include, either way, that we're sick of the crime. And that, you know, we got to stop trying to prosecute crime as a civil proceeding in a civil court. It's not the right place for it. And I think that given that we have entertained every single illegal contemplation that this land grab has ever come up with over the past 50 years or more, at least twice, that it's now time to finally entertain the effective actions of criminal justice. You know, what's behind this? They're the ones who need the tiny homes, but with bathrooms, you know, and sinks. That's who needs them. You know, the veterans who are in CTRS in wheelchairs with feeding tubes in sheds that are flammable for 3 years without toilets and sinks, as well as all the rest of them there, they need building 220 3 months from now, by 2 years from now, from before now. So, and sorry, there's something important that I forgot to mention, and I was reminded many times not to forget this, and I forgot it, which is possibly one of the most important things. The appeal. The appeal documents, the federal government's appeal filing is in that Google Drive directory, as well as video coverage of the federal government's testimony in the appeals hearing that has transpired, as well as the appeals panel's engagement and discussions on record. In the federal government's filing, what it is expressly saying, as you will see, is that the federal government's position is that it is appealing generally speaking, the unlawful overreach and control that the court is trying to take in this, and the unlawful business deals being made in the court, particularly for illegal land use. And it also expressly states, unlike any other party to the whole case, the federal government is the only party that is saying it is expressly not appealing to provide any right or stay to the illegal land use. The illegal land use has to go. It has recognized it screwed up, it effed up, and it's gotta take it on the chin, and it's time to go, to say the least. And then when the federal government testifies, as you will see in the segments of the hearing there, they say it again, under oath, testimony. And then we see the appeals panel state, you know, in more or less words, that's nice, I guess you should be doing that, but we're still going to be up your ass. And this is not only a matter of what has happened with the Westerly Leasing Act. This has to do with the deeds, the prevailing authority, the deeds accepted and agreed to under acts of Congress on record permanently. So that's what's happening in the appeal. But I haven't seen news to that effect. What I've seen is I've seen, you know, articles kind of insinuating that the appeals panel is bad and, you know, screwing up and holding up housing, which I guess is, you know, modular trailers next to a freeway instead of, you know, working on the permanent housing, of which hundreds of units of permanent housing, although they are involving fraudulent deals, still have been delivered since the time, you know, of this court's final judgment order already. And I haven't, you know, and what I've been seeing is, you know, Admiral Mike Mullen joining in with an amicus brief. We're talking about the same Mike Mullen who's with the 1887 fund nonprofit that was busted by the Inspector General. We're talking about the same Mike Mullen who is involved with as a co-founder and officer of Vets Advocacy, the lobby against everything that veterans want as they're entitled to in their land there. The same Michael Mullen who's running a website through Vets Advocacy, trying as a backup to turn the whole thing illegally into a national park instead of housing for veterans. The same Michael Mullen who in the Santa Monica Press provided an interview in a presentation in 2015 saying in 2015 that homeless veterans prefer to live outside in sheds, and that his friend Rick Caruso might be willing for free to come up with a new way to more properly redevelop illegally the property. That Mike Mullen, who's there putting forward an amicus curiae that really tugs one's heart among people like us who have a good heart and good faith, but for a malicious purpose, twisting things around. And that is very disappointing. And I'm sure that might have something to do with why the attorney who filed Mike Mullen's amicus brief to the appeals court is one of the best criminal defense attorneys in Los Angeles, with UCLA as a client.
Wow. Unbelievable. Well, unless there's anything else, I mean, I got to conclude. I did drop the link to the Google Drive in the video with the YouTube video rolling now. So if you have that link and you go to the description, you will find the Google Drive that we shared a handful of documents from. And if there's anything else you want to say, I was going to say, yeah, go ahead. Was there anything else you want to say or mention, or?
I'm good. I know there's some time issues going on. I very much appreciate the time to explain this. I wish we did it before. So I just hope that we all understand not what I say, what Carter's orders say.
Make sure this works. There's also a barcode. Just triple checking that's correct. There's a barcode. Yeah, the barcode on the screen right now. Also, if you scan the barcode on the screen, it will open up the Google Drive as well. Also in the YouTube link description. And yeah, if there's any follow-ups, we'll definitely do one. There's a few. If this is the first time you're watching, there's maybe 2 episodes we've done before where Ryan and I've discussed the Soldier's Home. So feel free to check those out. And we will definitely share again. I'll leave it with Commander Francisco Juarez comment here. One is enforce the laws. And then this one here, there was no settlement, which we touched upon. So thank you, Ryan, for sharing all this. This will be public. It'll be live. You could share it. And appreciate everyone for tuning in here.
Thank you very much.
Oh, Ryan, one thing. Do you want to say how people could contact you?
You can contact me via email at Ryan, RYAN, at giantsteps, GIANTSTEPS.US.
Ryan at giantsteps.us. Right?
Yep.
Sweet. All right. Peace, everyone.